And start recording.
I
I should probably get rid of this bar.
Ready?
guys.
Recording started. Good afternoon. For the record, my name is Jonathan Kwan, and this is the Criminal Law Procedure Review Commission plenary meeting. We're here for the plenary meeting of the commission. It is now 12 p.m. October 8th, and this meeting is now called to order. I note for the record, we are in person in the Judge Joaquin V. Manibusan Senior Memorial Courtroom in the Judicial Center. We are on Zoom for those members who are not able to attend in person. We are live on the Judiciary's YouTube channel. As this meeting is being recorded, to avoid background noise, I ask members appearing by Zoom, please mute yourselves unless you are speaking. And if you are here in person, please wait until we position a microphone before you. At this point, let us move to agenda item 2. On agenda item 2, due notice. I note for the record that due notice of today's meeting has been provided pursuant to the requirements of the open government law. Copies of the newspapers notices are included in your packet. Let's move to item 3. On agenda item 3, quorum, we'll start with the roll call. Members who are here, when your name is called, please state present and the location you are appearing from. May I ask our CLRC Administrative Assistant, Ms. Ibanez, to please call the roll. Please, ma'am.
Honorable Jonathan Kwan,
Present, Judiciary of Guam.
Honorable Maria T. Senthon, Honorable Anita A. Cipolla,
Present, California.
Attorney William Bucky Brennan,
Present from my office in Agana.
DOC Designee Major Anton Uggan, Chief of Police Designee Sergeant Michael Elliott,
President Tizen Guam.
Attorney Joseph B. McDonald,
Present, Sinahanya Guam.
Attorney F. Randall Cunliffe,
Present in Tamuning.
Mr. Monty McDowell, Public Defender Designee Attorney John Morrison,
Present from my office in Sinahanya.
Attorney General Designee Valerie Nuesa,
Present from my office in Agana.
Attorney Michael Phillips, Miss Valerie Regis, Attorney Christine Tenorio, Attorney Philip Tidinko,
Present courthouse.
ex officio members CLRC Executive Director Serge Kanga,
Present at the Judiciary of Guam.
Compiler of Laws Jerry Cepeda.
Present at the Judiciary of Guam.
Thank you, Mr. Chairman. There are 10 commission members present.
Thank you. I ascertain that we have a quorum and can conduct the business of the commission at this meeting. I'd like to welcome all those who are present, as well as any other visitors who are present to watch these proceedings.
I'm sorry, Mr. Chair, there are 9 commission members.
9. Thank you.
present.
We still have a quorum. Is that correct, Mr.?
Yes, that is correct.
Okay. At this point, the next item, agenda 4, the minutes. We have the minutes of the July 31st, 2025 plenary meeting. These minutes were provided in the meeting packets for the members' review. May I have a motion to approve both minutes?
So move.
Is there a second?
I second.
Thank you. Any opposed? There being none, the minutes for the last 2 plenary meetings are hereby approved. All right. Agenda item 5, old business. Please put up the next slide, slide 3. May I ask the executive director to provide his status update and report?
Thank you, Mr. Chairman, and Hafide to the members of the CLRC and all of our volunteer members as well. This is an informational report in the 3rd quarter, which includes July, August, and September of this year. The CLRC issued its 2nd quarter report for 2025, which is posted on our webpage for everyone to review. Work continues on the review of Title IX chapters. Subcommissions have been meeting to the best of their ability. We encourage chairs and members to utilize our research attorneys, Gordon Anderson and Andrew Strigi, who, although they work remotely, are very accessible and very responsive. And they have provided excellent research and statutory analysis to the property, ad hoc, and Criminal Procedure Subcommissions. We are approaching the end of 2025, which means the commission must complete our work in less than 15 months by January of 2027, unless we ask for and get another legislative amendment to extend our deadline. I encourage our subcommissions again to reach out to me if you have any difficulty meeting or if you need any research done. Thank you, Mr. Chair and members of the commission.
Let's please move to slide 4. Okay. I note that the agenda has the Criminal Procedure Subcommission next, but the Executive Director has asked to take the Ad hoc Subcommission first. Mr. Executive Director, please proceed with your to Subcommission's report.
Thank you, Mr. Chairman. I am presenting this report on behalf of the Ad hoc Subcommission on Corrections-related chapters. Our members include Attorney Christina Baird, Attorney Mary Hill, Chief Parole Officer Michael Kinata, Chief Probation Officer Rosanna Villagomez-Bogan, Probation Officer Supervisor Jeremiah Cruz, Marshals Kennedy G. Robinson, and Doug Siegfried Mortera. Next slide, please. So today, we will be continuing our discussion on Chapter 80, which is the disposition of offenders. Specifically under Article 2, imprisonment, we will be discussing sections 80.30, 80.34, and 80.38. Next slide. So starting with section 80.38, our research attorney, Gordon Anderson, presented on this section to the Plenary Commission at our last plenary meeting in July. He presented this case, People versus Murtaugh from Guam Supreme Court 2003, which held that this section is unconstitutional as it violates the rule expressed in the United States Supreme Court's Apprendi decision because it impliedly removes from the jury and prescribes to the court the duty to assess the facts that increase the prescribed range of penalties to which a criminal defendant is exposed. Next slide, please. So the questions that we considered is what should be done with section 8038, which was voided by the Supreme Court. Should it be repealed, or should we consider amending it to remove the constitutional infirmity? One example that Gordon presented was to follow what the state of Hawaii did in Hawaii Revised Statute section 706-662. Basically, it removes the language, if it finds, which removes from the court the responsibility to make a factual finding. And then we add in, is proven beyond a reasonable doubt to the end of this sentence. Next slide, please. In considering reasons for repeal or amendment, we first ask the question, is there a need to fix the statute? The first glaring observation is that section 8038 was found to be unconstitutional in 2003, some 22 years ago, and it has not been fixed since. In 2015, the Guam Supreme Court in People versus Tatato, 2015 Guam 9, indicated in a footnote that the constitutionality of section 80.38 might be worth revisiting. The court noted factors other than prior convictions which might be found by a judge without violating Apprendi. However, in that case, the Supreme Court declined to reach the issue. So to date, and to our knowledge, no efforts have been made to amend section 80.38, and the obvious conclusion is that the section is simply not necessary. Consider also that the Model Penal Code, Section 703, which this statute was adopted from, was essentially repealed by the American Law Institute in 2017 when comprehensive changes were made to the model sentencing and correctional provisions. Moreover, when we discussed in the ITAC working sessions and raised the question to attorneys in the property subcommission at their working sessions, the common thought among these attorneys who had both prosecution and defense experience was that the fix is not necessary. Given this, the ad hoc subcommission is not inclined to recommend any amendment to fix section 80.38. Next slide, please. So it's also necessary to point out other statutes in Article 2 that are affected by the Murtaugh case. Sections 80.40 and 80.42, as shown in the highlighted text here, contain the same infirmities that 80.38 does. So these two sections would also be unconstitutional under Murtaugh and should be repealed if 8038 is repealed. Next slide, please. Other affected statutes as shown here are 80.32, 80.36, and 80.44. Now, if you notice from the highlighted parts here, these sections make reference to the sections that that are unconstitutional under Murtaugh, and therefore these sections would also be repealed. Next slide, please. So in summary, the ad hoc's recommendation is to repeal 80.38. As the Supreme Court ruled in 2003 that it was unconstitutional, and it has not been amended since. Now, although the fix might seem simple, we are simply not compelled to feel that the fix is necessary. And again, repeal of 80.38 would encompass sections 80.40, 80.42, 80.32, 80.36, and 80.44. And we will sweep through the GCA for any affected statutes if our recommendation to repeal 80.38 is approved today.
I have a question. So 80.3, the recommendation would be to repeal, which means a required amendment for 80.40, a required amendment for 80.42, and a required amendment for 80.44. Is that correct? Amendments to those.
No,
Right.
that statute would also be struck down.
All of them.
Right.
Yeah.
Okay, so the repeal of all of them.
Right.
Okay, got it. Sorry. Good.
Now, they're already effectively repealed by Murtaugh.
Right.
So they have no effect right now. So we would simply be following the ruling in Murtaugh and removing them from the books.
Okay.
Other discussion on this?
No, it's a good recommendation. We should recommend that it get
Declutter.
repealed and clean up the statutes.
Okay, so there's nothing else. Next slide, please, Chair. So we'd like to next discuss the sentencing default provisions in Article 2. Specifically 80.38, duration of imprisonment for felonies, and 80.34, the duration of imprisonment for misdemeanors.
Court, we're gonna notice the presence of Monte Miguel and Phil Tenick, who are appear in person as well.
Now, at this time, the ad hoc subcommission is recommending no change to section 80.30 and the amendment in 83.4, as you see here, to remove the reference to section 80.36, which, as you've seen in the previous slides, would be repealed because of the repeal of, say, 80.38, according to the Murtaugh decision. The ad hoc subcommission and our research attorneys have spent a large amount of time researching, discussing, and debating whether any changes should be recommended to these default sentencing ranges, which have been unchanged since the 1970s. We looked at other jurisdictions and changes to the Model Penal Code sentencing provisions. However, we did not see significant differences to the terms of imprisonment for felonies and misdemeanors. And although I don't have the slide, I'll state for the record some of the comparisons between Guam and New Jersey. So in Guam, for first degree felonies, there's a range from 10 to 20 years. New Jersey has the same range, 10 to 20 years. Second degree felonies, Guam has a range of 3 to 10 years, whereas New Jersey has a range of 5 to 10 years. Third degree felonies in Guam, 0 to 5 years, and in New Jersey, 3 to 5 years.
Your slide says 5 to 20, not 10 to 20.
Oh, I'm sorry. Okay. All right, then I stand correct. And then for misdemeanors, Guam has 0 to 1 year, and New Jersey has 0 to 18 months. In the 2017 Model Penal Code sentencing provisions, there are 5 felony degrees ranging from the lowest felony degree, 3 years, the next one at 5 years, then 10, then 20, then life. Nebraska, for comparison, has 10 felony degrees, and these range from the low at 2 years to 3, 4, 20, 50 years, life, and then death. So although we did see divergence in the number of felony degrees or classifications in other jurisdictions, we did not see significant differences in felonies or misdemeanors for the terms of imprisonment.
Question. Those crimes like murder, I think also some CSC that carry up to life, that falls in the category of the first degree, right?
Yeah, but they're controlled by their specific statute
Right.
Right, so
in the chapter. Oh, sorry.
I'm just saying that the general definition of a felony first is not less than 5, not more than 20. Is that problematic? I'm asking academically.
Yeah.
I know what practice is.
Yeah.
I know the statute will say murder is a felony first degree, which can carry imprisonment of up to life of imprisonment with or without parole. Point being, should that be part of the general definition or not? It's like kind of an academic question, I guess.
Well, I think many other statutes, as you'll see, have extended terms. Some have lower terms than defaults. And so it just depends on what the legislature feels is right or chooses is right at a particular point in time. So they might be reacting to something that is happening right now in the community when it chooses to extend the prison time for a serious crime. Right now, there are, and I was going to mention this later, but there are 3 pending bills before the legislature to increase the penalties for graffiti, criminal sexual conduct against young victims, and one more that I can't recall off the top of my head.
I think Joe McDonald was.
Chairman McDonald, you had your hand up, please. Joe? Joe, unmute. There you go.
Sorry about that. Yeah, I did have a comment. Can you guys hear me?
Please, yes.
Okay, sorry. So I kind of think about this exercise as sort of negotiating with ourselves. And what I mean by that is it's fine, and I think it's good to compare to other jurisdictions, but without having any, because we're challenged right now with the overcrowding in the prison. And so we're challenged with revising the sentencing scheme without having any empirical data analysis. We don't really know what the composition of or we may have the data, but we don't really know what the composition term of the imprisoned population is at the prison. And we don't really have a sense of proportionality without knowing what these average sentences are, how long the terms are, the actual. It also gives us insight to the jurisprudence on the sentencing. So I think it's great to compare to the other jurisdictions, but really to localize it and actually to inform a decision at the legislature I would think that we would want to have some meaningful discussion about what the impacts would be. And that way, it's more of a forward-looking instead of, like I said, kind of negotiating with ourselves by pinging other jurisdictions, which sounds it's good and it's what lawyers do. But I think for practical effect, it would be nice to sort of understand what empirically this means and understand the trends in sentencing and the jurisprudence that's being handed down in sentencing.
Well, I'm glad you brought that up, Joe. I'm going to touch a little bit later on some of the difficulties that we faced in looking at whether to increase the default ranges. And then we'll survey through the other sections of law throughout Title IX. And then I will be making a little bit of present some information on sentencing reform. So I think as we may all know, several other jurisdictions throughout the United States have formed either permanent or temporary sentencing reform commissions. The federal government, I think, has a permanent sentencing commission. And so these dedicated commissions do what I think you're suggesting, looking at data and empirical information from prisons and the courts and from other sources to determine if in their jurisdictions sentencing reform should be put in place. Now, whether we have the ability to do this kind of work in one particular subcommission, apart from what other subcommissions are doing in their review of statutes, chapters that were assigned to them, without getting all our heads together, I think it's going to be very difficult. And on the other hand, we have the general mandate to review all of Title IX and all of Title VIII. So I don't know if we can do both, if we're responsible for doing both. We are mandated to review penalties and fines, and we are doing that to the best of our ability. And I do feel that we do have the constraints of having the overall comprehensive review that we have to be cognizant of. And working within those limitations, we'll do the best that we can. And maybe what you're suggesting, Joe, is a recommendation to the legislature that they create a Guam Sentencing Commission to look at all of these issues and look at all the social, political, and other things that come into play with overcrowding at the prison, treatment, rehabilitation, and incarceration.
Yeah.
I think that's exactly right. I think that's
Yeah.
exactly right.
To jump onto what Joe and Serge are saying, I've always thought that perhaps we may or may not have evolved into something we could suggest to the legislature that they look at considering a sentencing commission, if not to review, but also perhaps to consider, and many states do it like the federal government, which is to have sentencing guidelines. In other words, incorporating the factors we have in our statutes already, perhaps into a sentencing guideline. I don't know, but anyway, that kind of dovetails into that. But I think the point's well taken that, and I don't think the folks here are touching the ranges. No, you know, we're just sort of kind of, when it comes to sentencing, we're just sort of cleaning out the legal inconsistencies that may be caused by changing or amending, recommending changes or repeals of other related statutes. So, but your point is well taken that it needs to be data driven if you're going to make any change for the legislature, of course, to make changes to the sentencing ranges or punishments or whatever they want to put as a consequence, legal consequence for committing crime. So, but yeah, good point.
Okay, next slide, please, Jerry.
Mr. Chair, for the record, I'd like to note that DOC designee Major Antoine Akin has joined us on Zoom.
Welcome, Adrian.
If I could interject this quickly, that, what we're doing here And of course, I'm a non-judiciary type person, but when you start bringing in the prison and overcrowding, it just seems to me like that's overstepping what we're trying to do. Are we gonna concern ourselves with that fact, or is that the fact that the government itself has to take care of it? If they feel they need to come back and amend the laws for some reason, that's one thing, but I don't believe we were asked to consider the prison and its current state as part of our review process.
Agreed,
Quite funny, thank you.
absolutely. We get the input from the prison directly from their representatives, so it's considered in the thought process, but we're not mandated, as you said, to address that directly.
And it's a big problem. I'm just not gonna say it's on the news every day of the week. Somebody just lost her life up there yesterday.
Okay, thank you for all that great input. So in this slide, this shows departures from the general default ranges in Article 2. And these are departures in Article 1 and Article 2 alone. 80.22 reduction by court of degree of offense, 80.31 prison terms for offenders, and 80.39 its sequence, the Justice Safety Valve Act. Just to illustrate some of the things that we have to keep in mind if we are going to recommend any changes to the default ranges in Article 2. Next slide, please. So more sections, as I alluded to earlier. This table shows several departures from the minimum defaults for specific offenses. First degree CSE, for example, 10 to 15 years, family violence, a year, so on and so forth. Next slide, please. This table shows departures above the defaults for specific offenses. For example, first degree kidnapping, 10 to 25 years, first degree robbery, 10 to 25 years, and so on. Next slide, please. So this slide shows ranges below the defaults for specific offenses. Graffiti, which is being considered now for amendment, theft as a second degree felony, unlawful use of telephone records, and so on. Next slide, please. Directed sentences, aggravated murder, life without parole, murder, life, and so on. Next slide, please.
Hold on, was that comprehensive? Was that everything?
No.
That was,
No, this is just a few of the statutes outside of the default I'm sorry, a few of the statutes that occur throughout Title IX that go beyond the default ranges, either up or down, that are in Article 2 of Chapter 8.
but not comprehensive.
Not
So
comprehensive.
in other words, the exceptions are swallowing the rule functionally.
Well, yes, that's the other thing. Next slide, please, Jerry. So, and as I spoke about earlier, although our enabling law requires us to adjust penalties, fines, and gradation of offenses to provide for proportionate offenses, amending the default ranges in Chapter 80 might affect the specific prison terms across all these chapters in Title IX. Although we'll do our best to the best of our ability to do this, given time and resource limitations. And I'd like to also point out that some of the sections that were in the tables that you saw in the slides before have already been looked at and either amended or recommendations for no change were made by the subcommissions that were assigned to those sections. So again, what effect would amending the default ranges have on all those other statutes that were in the tables before this one? That would, the comprehensive review of sentencing ranges has to encompass everything. And so there are many different sections outside of Chapter 80 that affect sentencing for specific offenses. And
I was gonna say, sorry to interrupt, but are you hinting that this is beyond the scope of our abilities?
that's kind of what I'm saying. Well, again, we're mandated to do it, and we'll do it to the best of our ability. I think that maybe part of what we've done earlier in our recommendation to remove Section 80.38 because it was found to be unconstitutional under Murtaugh that is encompassed by that, by this mandate. So we're doing what we have to do and looking at the law to see if it still needs to be in the code. But what we're looking at now is true sentencing reform, which we spoke about recently in lots of useful comments.
Which is not us.
Right.
Which is not us, right?
And the next slide, please, Jerry. And just as an illustration, these are the state and federal sentencing commissions that we found. This is a couple of dozen throughout the nation. And if you like this information, I can send it to you. This actually comes from a website with links to all of these different commissions.
Okay.
Next slide, please.
He's showing that just to show us that a lot of jurisdictions have this challenge.
Problem.
Yeah.
Yeah, and the same problems that we're facing here.
People that look into it.
Right. And these commissions are made up of people from across the community, just like our commission is. Legal academics, law enforcement, prosecution, defense counsels. Sort of a mirror image of our own commission here. So given all this, we submit our recommendation to the commission for approval. And I'd like to thank you, Mr. Chair, and members of the commission for listening.
So what you're talking about is repeal from 80.32, 80.36, 80.38, 80.40, 80.42, 80.44. Recommendation is repeal. 80.30 is to leave as is, and 80.34 amend just on the verbiage.
Correct.
Okay. At this point, that's a recommendation. Is there a motion to accept this?
I move that we accept it because those repeals are the Murtaugh issue and Apprendi issue. So yeah, I move that we accept this recommendation.
Is there a second?
I second.
Thank you. Is there any opposed to the ad hoc subcommission's recommendation? There being none, this passes. Move to the final reading file. Thank you all. Thank you, Mr. Executive.
Thank you.
Good work. That was quite a bit of work. Okay. Next matter is, give me a moment. Since there's no further discussion, I'd like to move to the next subcommission report, which is the subcommission on criminal procedure. Mr. Executive Director, I understand Judge Sokola's on the line, but she's letting you take this one.
Yes, thank you, Mr. Chair. I'm presenting this on behalf of our chair, Judge Sokola, and members of our subcommission. So this is a report of the subcommission on criminal procedure. And again, our members are Judge Anita Sokola, Assistant Attorney General Valerie Noesa, and myself. Next slide, please. So today we'd like to continue our discussion, which I think we've gone back a couple of plenary meetings, and discuss today, present recommendations on sections 7.86, 7.96, and specifically for Articles 4 and 5, the duty to retreat. Next slide, please. So starting with a couple of relatively non-substantive recommendations. First, on section 7.86B, we are recommending these changes for consistency with the terms serious bodily injury and criminal sexual conduct, as these terms are specifically defined within Title IX. And by the way, kidnapping is also specifically defined in Title IX, so we don't have to change anything there. So this is submitted for consideration and approval. Next slide, please. On section 7.96C, in our review of Article 4, we notice discrepancies in the title of this section when compared to the reference section numbers within section 7.96 sub C. So I went back to the 1977 Criminal and Correctional Code and looked at this section 7.96C there. The correction noted here is to fix the clerical error, the obvious clerical error that occurred when the 1977 code was converted to the Guam Code annotated. This correction was confirmed with the compiler of laws. Deletion of the section numbers from the title is intended to remove any possible error or confusion. Since titles have no force of law, this change is non-substantive. So I submit this for consideration and approval of the plenary commission. Next slide, please. So turning now to a more interesting issue, the Criminal Procedure Subcommission spent a lot of time reviewing, researching, discussing, and debating Articles 4 and 5, specifically the duty to retreat. Stated another way, it's rather the no duty to retreat language in both articles. So the table that you see before you shows pertinent information for comparison. Article 4 is a title justification. It is our self-defense law. Article 5 is a Castle Doctrine Act. Note that Article 4 also has a castle-like stand your ground provision, which we'll get into a little bit later. Article 4 is from the 1977 Criminal and Correctional Code with its source in the Model Penal Code. It has remained largely unchanged since 1977 and was apparently amended only once by the original Castle Law in 2014. Under Article 4, self-defense is, quote, a defense. Interestingly, the Model Penal Code source section defines self-defense as an affirmative defense. Our legislature long ago decided to admit affirmative when it sourced the language from the Model Penal Code. There is an old compiler comment that comes right out and say that this is not an affirmative defense per, and I'm quoting here, 8 GCA section 85.22. This section does not exist, and I have not found any history of this section 85.22. I think I conferred with the compiler on this, and we both agree that there's just no trace, no sense, or any meaning for this section to be referenced, 85.22. So like all the other older compiler comments that a pioneer explained the law, I'll leave it to the current compiler to strike as necessary. So the duty to retreat language for discussion today under Article 4 is in section 7.86BA. It states that the defendant is not obliged to retreat from his dwelling, place of work, or vehicle unless he was the initial aggressor. I'll note here that the term vehicle was added by the Castle Doctrine Act in 2014, and the initial aggressor is the exception to this stand your ground provision. Article 5, again, the Castle Doctrine Act was enacted in 2014 by Public Law 32-111 to establish defense in habitable property as an immunity. It was amended just last year to add curtilage to the definition of habitable property. The duty to retreat language for discussion today is in section 7.112D6, which states defensive force has the same meaning as self-defense as used in Chapter 7 of Title 9 GCA, except that a lawful occupant of habitable property has no duty or obligation to retreat. In blue, you see here self-defense as used in Chapter 7 of Title 9. And again, just to mention that self-defense is specifically defined in Article 4, the justification article that we just went over. So our debate in the Criminal Procedure Subcommission focused on the initial aggressor exception in Article 4, whereas Article 5 has absolutely no duty to retreat and no initial aggressor exception. When we were going over this difference, this major difference, initially suggested to us that it might be an irreconcilable conflict between these two laws. Next slide, please. So the questions we considered were, should we amend Castle to add an initial aggressor exception to remove the potential conflict, or should we just leave it alone? Next slide, please. So reasons for no change to Castle that we were discussing was that the legislature was surely aware of the initial aggressor exception in the duty to retreat language in Article 4 when it enacted Article 5. First, Castle directly refers to self-defense as defined in Article 4. And second, in 2014, when Castle was enacted, the legislature added the word vehicle to Article 4, Article 4's duty to retreat provision, to bring Article 4 consistent with the Castle Doctrine Act. And the legislature continues to enhance and expand Castle like it did with the amendment just last year to add curtilage to the definition of habitable property. Also, and probably very important, it may be possible for a defendant to assert self-defense if for whatever reason their Castle immunity claim fails. I'll also note that we have found no Guam case law on this specific issue, and that Castle strongly reflects policy set by the legislature.
Sir, can I ask you to articulate in simple terms, what's the potential conflict
Between Article
between the
right.
two? Between the two, that's what I'm trying to
Right.
reconcile it in my head, especially overlaid on this, that you also, which kind of intrigued me, you said that the earlier compiler was declaring it not as an affirmative defense. All this time I've viewed it as an affirmative defense.
Just called it a defense.
Huh?
You just called it a defense.
Oh,
It's an immunity. The castle is.
no, I know the castle, I'm talking about the self-defense.
Right.
I thought that was an affirmative
Right.
defense.
It's just a minute. Just.
Well, that's the thing.
a defense.
Model Penal Code calls it quote unquote an affirmative defense.
Which is what it was originally designed.
Not in
under.
Guam law, though.
Huh?
In Guam law, it simply says defense.
Defense.
No, I know it says defense, but I thought it was based, the 1977 criminal code worked off of the model penal code.
It did.
But in trial, we have to affirmatively.
Right,
Yeah.
right, and the
We-
jury instructions, and
Right.
so,
So
I'm just saying, does
Right.
that, does expressly identifying it as an affirmative defense, is that needed, number one, and number two, does it change whatever's the conflict that you folks see with having initial aggressor in there versus not in the other one?
I think not considering the differences between the two articles, right? With article having establishing an immunity and self-defense.
One is
A defense.
procedurally an immunity, right?
Right, which requires
So
a
it's
separate
different
hearing.
analysis.
initially
Yeah,
in
that's a
front.
separate hearing, so what's I'm trying to understand what's
So
the
just on their face,
conflict?
the two conflicts address the same thing. The two statutes address the same thing. If you're in your dwelling under Article 4, you have no duty to retreat unless you're initial aggressor. If you're in your habitable property under Castle,
Even if you are the initial aggressor,
you have
still
no
have
duty
it.
to retreat, period. So
Yeah.
that's the
that's the difference.
potential conflict that we were looking at.
So what I'm seeing, based on our discussions on this,
No,
is
again, what's the conflict? You're
there's
saying
none.
that's not a conflict to me,
It's
that's
not.
just that may be a moral conflict, I mean,
Yeah.
I don't like the idea morally
Of the
or
initial aggressor.
socially
Right.
of the initial aggressor, that's.
Wouldn't it be an element then to show that who's the initial aggressor?
For
Or not.
For a type of
rather,
No, not for-
For
not-
raising the event, the defense.
No, that's
For-
for the immunity,
for raising the immunity, not for the defense.
for the defense, I'm sorry,
Yeah.
you're right.
Yeah,
If-
so that's the difference.
Yeah, there's no conflict.
Yeah, but it's not a conflict.
It's just a circuitous hot mess
When
of.
you use the word,
So yeah,
does this mess up
Right.
the practitioners?
No.
And the court when they assert
Both.
doctrine, the immunity claim first, separate hearing. And then if you lose on that and you're gonna go to trial,
It's defense.
it's the self-defense. So I'm saying, what's the conflict?
It's not.
Discrepancy.
It's just messy. It's just very messy and ugly, but it's not conflicting.
So that's the analysis.
Almost like, let's leave it alone.
Yeah.
Because it's messy.
It is messy, yeah.
Right, right.
So how I see this, please, Monty.
No, it's one of the options, leave it alone.
Right.
Yeah, I mean,
So what I'm seeing, based on what Serge is saying, what the statute says is, so let's assume a guy punches another guy, hits him with a stick. Then he runs into his house. Okay. At that point, the victim takes out a knife, bangs on the door, and then the guy opens it. The initial guy opens it
he shoots.
and shoots him. So the castle doctrine will apply, but not self-defense. Self-defense would be barred because he was the initial aggressor. And that the castle doctrine would be determined initially at a preliminary, a prior hearing. And if it fails, the self-defense is not viable as an affirmative defense at trial.
Right. But there might.
And that's a policy decision.
That's
The
what they
legislature
decided that,
made,
yeah.
saying that it's a special place, your house, your castle.
Even if you're the initial.
Even if it's, that's what I mean. It doesn't, it's a policy thing. So as opposed to, you get past that.
Yeah.
And I don't know what fact pattern would get you past that.
Right.
And the one you just did, you know, unless the victim turns around and runs when he sees the gun and then you shoot him in the back.
While he's in the curtilage, right?
So, yeah, so there you go. But, I mean, I'd say leave it alone.
Right.
It's very messy. It's not, I don't see.
Anyway, that's my comment. Yeah.
Yeah. So that, yeah, again, the questions we considered were whether castle needs to be amended or whether no changes should be recommended. So going on to the next slide.
But before you leave that one, this is even more complicated, not conflicting, but complicated because it's both include vehicle. So you have the same scenario. Instead of running to his house, he runs into his car. At that point, it gets even more messy, but it's not in conflict.
Right. So our recommendation ultimately is no change to castle. Although we went through the entire process, the entire analysis, because of the what we thought was an apparent conflict, was a potential conflict. And again, the legislature was aware of the duty retreat in Article 4. Castle's duty retreat provision refers to the definition of self-defense in Article 4. When the legislature enacted Castle in 2014, it amended Article 4 to add the word vehicle for consistency. Just last year, the legislature expanded Castle to include curtilage. And it may be possible, without necessarily dreaming up or thinking of a hypothetical, it may be possible for a defendant to assert justification for self-defense as a defense if, for whatever reason, the Castle immunity claim fails. We found no Guam case law addressing the potential conflict. And again, it's the legislature's policy. Next slide. Again, our recommendation is no change. And although the language is awkward, and maybe it'll present conflict issues to the courts in the future, we're not compelled to recommend any changes to Castle. And we invite discussion, which we've already had.
Right. Is there anyone else who wants to chime in on this? Mr. Cunliffe, Jessica, anybody? Mr. McDonald, anybody? Okay.
Okay. Then next slide, please, Jerry. So then we submit our recommendations, Mr. Chair, to the commission for its consideration and approval.
Okay.
I move to accept the recommendations.
So this one just for the recording.
Yeah,
We're talking.
this is Randy.
Hello.
Can I make a comment before we get to that point?
Please, please.
So in 7.86, you've changed rape and sodomy to criminal sexual conduct.
Okay.
Third-degree criminal sexual conduct is the inappropriate touching of somebody's buttocks or inner thigh. Are you telling me that I can kill somebody if they try to do that to me?
In your house?
No.
Car? Are you talking about this?
Self-defense is limited, right? I can't defend. I mean, I can use deadly force if somebody tries to touch me.
Back up.
Can you go back up?
Gotta go
Back up to you're talking about the other statute.
Back up.
There you go.
There you go. Self-defense limited.
Well,
7.86. It says deadly force is not justifiable unless I'm using the force to protect myself against somebody gonna touch my butt.
Well,
that's a good point. I mean,
I mean, you know, maybe second and third degree criminal sexual conduct might
he
apply,
said-
but that's why they use rape and sodomy.
Talking about first or second degree.
you're talking about first or second, it should read, we should recommend first or second degree criminal sexual conduct.
okay.
Good point, Brad.
Good call. Well,
Definition,
sorry.
definition of intimate, intimate part under CSC.
Yeah. Buttocks, it includes buttocks. Buttocks, inner thighs.
Inner thigh, your
Right,
breast, your genital areas,
right.
the touching.
Are you comfortable living in first or second degree?
Yeah, I mean, I think it's a little overboard that I can kill somebody for trying to touch my butt.
Well,
Yeah, especially, well, I guess coaches don't pat
Well,
people on
yeah.
the butt anymore, but, you know,
This is to be voted on.
yeah, we have to. No, he's.
we have to table it then.
We haven't voted on
Point.
it.
We have to table
We have
it.
to table it.
We don't necessarily, if we want to.
We have to table it. So
Okay.
I'm suggesting tabling so you can fix it
Okay.
to clean it because this was voted on earlier, but Mr. Cullers raised a really good point.
Yeah,
I mean,
I think we table it with the idea of amending it to have the first or
first, second
second
degree.
Okay. Then we'll look closer at the criminal sexual conduct statute.
Good catch.
Okay, we'll bring it back. So go back to the table.
Apparently, Mr. Cutler doesn't value his
Well, I don't-
derriere as.
I hear you, I will be killed too, cause you know,
We're particularly sensitive.
pat the dog on the
That one's tabled. Okay, go back to the voting sheet. Okay, so 7.86 is gonna be tabled. And then we have at this point, the subcommission recommending an amendment on 7.96C. And then no change to castle. Anybody, is there a motion to accept?
move that we set those right.
Is there a second on this?
Second,
Anybody opposed to 7.96C and castle as proposed? There being none, motion carries. Move to the second reading file. For the record, 7.86B is tabled to allow the subcommission to look at the potential revision to exclude third degree CSE.
Got it.
I want to make the Cunliffe amendment.
We're gonna call it the Cunliffe Amendment at this point. All right.
Thank you.
Thank you. At this point, that is, anything further on that? Just none. At this point, the next slide is a subcommission presentation, subcommission relating to property. Attorney Tedinko.
Okay,
Please go ahead, sir.
let's go through, I think we were assigned, the, chapter 61. Yeah, on, we'll start, is the first set, 61 or 58?
58 comes first.
Oh, 58 comes, okay, let's go to chapter 58, we were given that one. Can we get to the next slide? So, by the way, we had invited, DOC representative, which I think was Major Anton,
Yes.
to also participate in this. But the only changes in reviewing chapter 58, which curiously has DOC type related statutes, which are particularly the escape and the contraband. We just wanted to make it simple, like we've done through other parts of the of statutes from our subcommittee, which is to simply put a period after wherever we see misdemeanor or felony, second degree, and recommend deleting the minimum mandatory imprisonment ranges and fines. And so that's what we propose for amending 58.60, which is just to delete the minimum mandatories that are put there. Next slide, please.
And
I'm sorry,
back up to
go back.
the bottom.
Oh, and no other, I'm sorry, and then no other changes to chapter 58, which has other escape provisions. There was no need to make any changes there. Okay, now we're on 61. chapter 61, which was assigned to us by disorderly conduct. And here the only recommended change was the title to add as a heading for clarity purposes, and to just simply clear up the mens rea and just only have to state it once, the knowingly refuses or fails. Just more grammatical. And so that's what we recommend for 61.10B. Okay, next slide. And then for harassment, by the way, I want to thank Ms. Attorney Andrew Strategy, who assisted us with this and did research and helping us come to these recommendations. We recommend the original language has this inoffensively coarse language, and the constitutional case law tends to use fighting words likely to provoke an immediate violent response, as opposed to the offensively coarse language, which implicates First Amendment, especially in this day and age of how people talk to each other or yell at each other. So we recommend using the constitutionally accepted phrases for this harassment. Next slide, please.
Wait, back,
Oh,
I'm sorry, back up. So, in other words, you're effectively decriminalizing cussing, functionally.
Yeah, I mean,
It's okay.
but I don't think the I that's not.
Because before you could charge someone for just leaning over at you while you're trying to get in your car, just cussing at your face, assuming you're not a public official, cussing at your face, just cussing at you. You
Right.
could be charged with harassment.
Right, yeah.
But right now, with that recommendation, that is no longer.
Yeah, if you just leave it as offensively coarse language, based on the research, it would appear that would raise First Amendment challenges. So if someone got charged with, hey, I said F you to you, I mean,
Right.
they would be able to make a First Amendment challenge of why are you charging me with harassment just because they said F you.
Okay.
It's free speech, right? I mean, politicians making that and or in the city council, he says F you. Of course, he can be dragged out, but for disruption. But just the language alone, I don't believe will survive a First Amendment challenge or defense to that charge. And that's what the research showed.
Thank you.
Okay. Next slide.
I can't even present it.
So the recommendation was to revise this, take out the
all of it.
Yeah, the repetitive technology specific language. He recommended writing it into more broad, medium, neutral provisions, because I think the original language talks about outdated technology or that's no longer used. I mean, I don't know. There was telefax, or I don't know if they have pagers or beepers. Anyway, point is to make it broad so that we can encompass the electronics that are of these 2020s. So that's the recommendation with this language, which he researched to see what would be more contemporaneous and broad in terms of the medium, the electronic medium.
I'll just read it. So the person who gives you in subsection E leaves the phone there unlocked to allow you to digitally harass someone would be guilty.
I think so. I think so. I mean, of course, it's a proof issue, but yeah, it's an evidentiary issue, but yeah. The point here is to have workable elements.
Right.
The other ones aren't really workable anymore.
No, I got it. Okay, I understand.
Anyway, that's the recommendation. I'm just glad that he was able to kind of put it broad and more broad neutral provisions.
So it cleans it up, that's for sure.
Yep.
Yes.
Right, well, you know, there's been major changes since 2011. I mean, gosh.
Is there any discussion on this? It just seems to clean up all the old technology, telefax transmission. I mean,
Yeah, it just went, it put a lot of different net detail, you know, so
yeah, no.
this is more broad, you know, means.
And there's E. That's new, right? Subsection E is new.
Yeah,
Okay. So in other words, if that number keeps popping up on the victim's feed, and clearly it's not the defendant's phone, it's his mother or his sister or whatever, that person could be held responsible. That's fair.
yeah.
Okay.
Sorry, in subsection 3, subsection 3,
What?
D3, under subsection E here.
Should be, so you should say subsection 3.
D3?
D3, right?
Okay.
You're right. It should be subsection
D3.
D3.
Okay.
Yeah, it should be D3. I'm sorry. You're right. That's the only way that makes sense.
Okay.
Yeah, D3.
Is there any discussion on this?
Subject to that amendment, D3 anyway. That's what we would propose. Otherwise, can we go to the next slide if there's no discussion?
Mr. Cunliffe?
Yeah, can I just jump in for a second? I have to run to take a grandchild to a medical appointment, but Phil, on 6170,
Oh, you want to jump ahead? Okay, we can do that. Can we go to, because he's got to run. Go, can we go to 6170?
yeah,
There you
in,
go. Okay.
in under penalties, subsection 1, if you on the very last line, we went over this, but it didn't get changed. It says any individual so convicted who has legal possession of more than one firearm shall have only that firearm, the firearm used, confiscated. But we changed everything else to may, and I suggested we change that shall to may, but it didn't get done.
Oh, yeah, it's supposed to be May. I'm sorry. That,
I see.
yeah, it should be there. That should be May. You're right. Good catch.
Okay.
Okay, so other than that, yeah, I mean, I just wanted to get to that because I've got to run.
Yeah, that one was supposed to be May. You're right. Thank you.
Thank you, Mr. Cunliffe.
I don't know why it didn't get put in there, but
Thank you.
okay, thanks, Randy.
All right,
So,
I'm gonna get off now. Thank you,
Okay.
everybody.
but if we can get back to 61.30,
Hold on. For the record now, Mr. Cunliffe is off. CLRC, Mr. Banners, do we still have a quorum?
Still have quorum.
How many do we have?
Let me recount. We have 10.
Okay, that's fine.
okay, 61.30, we recommended adding justifiable and reasonable to make certain that there was no vagueness issue
Okay.
raised, so as well as cleaned up the bottom. Person commits a violation if he or she loiters or remains in or about a school bus stop, not having any reason or a relationship involving custody or responsibility of a pupil or student, or some other specific legitimate reason for being there.
So would that exclude, based on the case law of research, persons sleeping in there? Because
Yeah,
legitimate reason is a problem, right?
Well, I mean, who's the person? I mean, if the kid's sleeping.
No, not a kid. Like,
Oh, well.
you know, a lot of these.
I mean, yeah, I think it's meant to, I think it's meant to prevent that, prohibit that.
Would the legitimate reason be used to block a prosecution of that is the question.
If they can raise that as a defense,
No,
as a legitimate reason, my house got blown out by the typhoon, I'm homeless. I'm homeless. Well, I mean, that may be, you know, a legitimate reason if you can persuade the court that that's. Again, we wanted to have that in there because otherwise it'd be vague.
Okay.
So that's what we recommend at this time, unless there's discussion.
Just as a complication issue, if I can suggest, it would be A a person commits a violation if he or she.
Oh, okay, sure.
Alright, and then start some item one.
After loiter,
Loiters or
yeah.
prowls,
I mean,
and
before.
then- Yes, and then sub item two.
Two.
Would be if he or she loiters or remains. So it's cosmetic.
I know what you're saying.
Yeah.
Or wouldn't it be better just be A and B?
Yeah, and something.
No, one and two.
No, because you already have a B.
Oh, you already have,
You already have
oh,
B.
oh,
So
okay,
this
there's a
would
B in
be
there,
A1.
okay.
Yeah, this is A1.
A1, A2, I agree, I agree.
Okay, that's all.
So subject to that amendment, that cleaning, just that structure outline. We would recommend these changes.
Any discussion on this? Anyone?
Okay, 61.35. We recommend removing B because it was just redundant. And again, avoid the First Amendment challenges or defenses. So, remember, I think there's case law about the hand billing.
Hold on.
There's some aggressive,
Panhandling.
yes. And
Right, but B here is we think it's covered I think part of B is covered in A. It's just the hand billing part is a constitutional, if you recall our law school stuff.
This is the
We just thought it was redundant.
yes, especially with the panhandling.
Yeah, so that's what we recommend.
Okay,
Okay.
any discussion on this? All right, thank you.
Okay, and then for 61.40, disrupting public gatherings, if we just amend, take out the last phrase and just again, that would avoid the First Amendment and it's subjective. I mean, sensibilities of the group. I mean, so you got
Group of nuns praying.
you got the pro-life versus the anti-abortion group. So so that's what we wanted to avoid. Okay, all right.
Any discussion on that?
That's First Amendment cleaning up. Okay, 61.45, next slide, thank you. This one we recommended removing the flag desecration provision, although with these times, you never know, that might come back up to the Supreme Court. But for now, under Texas v. Johnson, it would be prudent to remove delete this last phrase to and again, it replaces that subjective object of veneration. So,
Well, you're tying it to.
desecration. So, anyways, that's the recommendation, unless someone thinks so.
So no, you're tying, so what I'm seeing in 61.45 is you're specifically tying it to an item or object where public funds were expended to purchase or create.
A public, so a public monument, structure, insignia, symbol.
So if a person.
That's a public thing, and then you got the place of worship or burial.
No, a flag still could be desecrated if somebody pulls down the flag that's hanging outside the judicial court building, pulls it down and then tries to burn it or paint it. Because it's
symbol.
Well,
Yeah, that would be symbol.
It would be covered still because.
Yes, you're right. It would be.
Not be covered as
Their
object
own
of
flag.
veneration.
Right,
own
what
flag.
we were taking out here was this other additional element of.
Yeah.
You intentionally did this. And the other or the alternative element, which is that it violates the sentiments, or it's venerated by the public, so.
That's the only thing that you've taken out that couldn't be subsumed into any of the prior descriptions.
Right.
So just to be clear, you can still, that subsection A still allows for the prosecution of someone who decides to desecrate a flag, so long as the flag is
If you
owned
go
by
over
the
here
public.
and you pull it down or,
Yeah.
chop down the flagpole, yes, I
Yeah.
think so.
Okay,
It's just that this other surplusage type,
got violates First Amendment.
Yeah,
technically.
it violates First Amendment under,
Would there be an object of veneration that's not a public monument or structure?
Yeah, Our Lady of Cameron.
But that's not included now.
Well,
It's
that's-
taken out.
yeah,
That's what I'm saying is that's the only.
But that would be criminal mischief. In fact,
Yeah, that's the only descriptor that's not included.
right, but that would be covered by theft, criminal
or
mischief.
criminal mischief, criminal
Right, property
property,
stuff.
yeah,
I mean,
So
I'm
you're
just-
tying it to public funds, which is fine.
yeah.
Yeah.
Okay,
Any other comments on this, anyone?
I just want to point out that missing an underline for insignia and symbol, those are added.
those are added, that's right, that's correct. Those are added. All right, 61.60, next slide. And we just, it was recommended we add accessible to children to make this clear what I think the policy or purpose of this statute meant to cover,
So you better have a fence around his field.
you know.
He better have a fence around his field. He's gonna keep.
Yeah,
Hazards.
yeah. So I just thought that was commonsensical, so, and it does mirror the California and New York's. Just makes sense.
Any discussion on this?
Okay. 61.65. This is dealing with certain hazards and oil pollution. And we just recommended adding a separate subsection 1 and 2 to make it clear that there are two types of vessels. That's just an outline structure recommendation. Okay, to make it cleaner to understand it. And
Can I comment on this section?
sure, please.
Okay.
This is the recommendation.
Right. So when property was looking at this section in their working session, the amendment to remove the language relating to a private place there in subsection B,
B.
it stood out so like a big red flag, and it caused me to take a really close look at this section. That language doesn't make any sense at all in this section on oil pollution. So I traced the history of 6165 from the current Guam Code annotated to the 2005 and previous versions of the GCA, to the 1977 Criminal and Correctional Code, then to the 1953 Civil Code and Penal Code of the Territory of Guam, and finally to the oldest criminal code that I'm aware of, the 1947 Penal Code of Guam. So long story short, the transcription or conversion of this section from code to code through the years is subject to clerical errors. The private place language was in a neighbor section and somehow was inserted into this oil pollution section. That's not all. We also found that another obvious clerical error. The original 1947 code contained the definitions for oil and navigable waters and a definition of person.
Persons, right?
But somehow the definition of persons was omitted. We did not see any reason that the person was left out while the other two definitions for oil and navigable waters were kept. So the definition of person from the 1947 code is placed back into this section 6165 with one modification. In the 1947 code, it references the naval government of Guam, and now it's just simply government of Guam. So that explains why this private place language was in here.
It was what do you call a generational typo, right?
That's great research.
Yeah, that is. And so that's the recommendation and the cleaning up of what do you call 60 years of errors, or is that 70 years of 40s? Golly, that's a lot.
I got a question. Persons, does that definition of persons conflict with anything else in the corporate? I mean, I'm seeing it in terms of corporate
But it just
section.
says as used in this section. So
Does
it's
it?
specific to this section.
Just
Under E.
specific to this section, as used in this section.
This. So it's limited.
It's limited to this particular offense.
LLC, does it cover LLC as well? Do we need to do that, or is it limited to company or corporation covered?
An LLC's corp.
Okay, just make sure.
Only thing an LLP's a partnership, it's just, yeah, so it covers it, it's broad enough.
Okay.
Okay, good question though. 61.70, discharge of firearms. Gosh, it's just, we thought it should be reorganized and make it readable and workable. So. I think it was just a matter of restructuring B into 5.
And that's the same language.
I believe so, yes, we just reorganized that separate element of the offense from the penalties section into the actual elements part, which would be A, right? A is setting forth what are the elements for that offense, as opposed to putting that element under the penalty section. It's just reorganizing something that, that's what made sense. And I think Jerry would have recommended that anyway, move it out of the penalty section. And that's basically and I think we also recommended to be generic about the fines and punishment, get rid of the minimum mandatories, and also make it discretionary.
And then Randy's correction.
So Randy's correction should be noted too, that where it says the last sentence of B1 should be may, okay?
So just to be clear, castle would protect you from prosecution under discharge of a firearm, but not self-defense. Under this. That's correct.
Yeah, I guess, yeah.
Castle would be right protection of this, but not discharge, not self-defense.
Into the air.
Like if you
Because
pulled a gun.
No, but
And
the
fired.
castle has, there's a
Castle-
second person threatening.
Castle will protect you. Yeah, let's assume somebody threatens you. You fire a gun, but you're the initial aggressor.
Yeah, but you don't get charged with discharge of firearms under the circumstance.
Yeah, no, I get it. Just I'm just being.
Yeah, this is.
You don't want
is
to kill
just-
him, but you shoot him.
Yeah, but this is just, to cover the,
Yeah.
what do you call it, New Year's and 4th of July,
Shooting the backyard.
AR-15 is okay. My neighborhood, so, okay. Oh, did I say that out loud? Sorry.
Your porch.
Kids, stay inside, it's 4th of July. It's Christmas.
I live in Haggard, trust me.
Oh, yeah, that's right, okay. Anyway,
Any comments on this?
any comments on the?
It being
All right, okay. And of course, we recommend no changes for 61.15, 20, 25, 50, and 55. Okay, can we go to the next slide? All right, I think,
Okay, so just to recap here, there's been subsequent changes to minor modifications to some of the language, but 58, 80, recommendation to amend, all others 58, no change. 61,
It's like that was 5860.
sorry,
58.60.
6110, amend. 6115, no change. 6120, amend. 6120.1, no change. 6125, no change. 6130, amend. 35, amend. 40, amend. 45, amend. 50, no change. 55, no change. 60, amend. 65, amend. And 70, amend, subject to Mr. Cunliffe shall to me.
Yeah.
Is there any discussion on any of these sections? There being none, is there a motion to accept these? So move. Is there a second? Is there a second? We need a second.
Second.
Mr. McDonald, thank you very much. A second. Any opposed to the subcommission on properties recommendation? There being none, this now moves to the final reading. Thank you for your work. Thank you for the significant work, gentlemen. All right.
Thank you to Mr. Andrew Strigy for his assistance.
All right, at
Really
this
appreciate
point, what we had left on the table was presentations by DOCO and by persons which have been requested to be tabled till the next meeting. That shall be done. At this point, agenda number 8, is that correct? There's no communications to represent. Notice of next meeting we will determine that and be, a later time will be announced to all the members. Once again, Doko and person should be prepared to present. Agenda number 7, no communications to present. And I8, are there any comments from anyone? There being nothing, I want to thank everyone for their work today and their presence. We've got a lot of work done today.